Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users getting focused the answers they need from an employment attorney. We have a question here from YouTube user Apocalypto V7F, who asked us, the jury gave her 30 mil, but the judge knocked it down to 3. Can you explain this? Kind of the whys and hows of this happening. Sure, happy to. So let's start with the basics. There are fundamental formulas in how economic damages and emotional damages are calculated in our field. And generally speaking, when you explain those formulas to clients, or you make videos on a YouTube channel telling people the formulas, they read the formulas and they will often say, okay, I understand the formula. It's clear to me now that I get 30 mil. And as an attorney, you're like, well, hold on, because I'm reading that formula, and I think you have a good case. It's a solid case. It's a claim. It's a valuable claim. I think it's more likely than not to make you money. When I read it, I see 280 grand. That's how I apply the formulas to your case. And the client or potential client will look at you and be like, well, you're stupid and you don't know what you're doing and you're fired. Fine, right? That's fine. And then they'll go out and they'll get 60 grand because they're either pro se or they hired a really shitty attorney. It's whatever it is. The reality of those formulas is that, generally speaking, unless you've worked with them for a long period of time, most folks don't seem to grasp how to apply them. And this will even go for attorneys. There are attorneys in this field who can't seem to grapple with the formulas for whatever reason. So, Apocalypto, when you're asking me what happened when somebody won 30 mil from a jury and then it got knocked down to 3 mil, well, the same thing happened to the jury that happens to a lot of clients and happens to some attorneys in this field, right? They saw a case and they were like, I want to help this person. I want to help this plaintiff. I want to fine for this plaintiff. Great. Same page. I'm a plaintiff's attorney. I love that about you. And the jury said, I see this formula here, and I either disagree with it or I think I'm applying it correctly, but I'm not. So I'm going to assign a valuation of 30 mil, even though this person earned, $50K a year. So 30 mil would be certainly not accountable. Not something you could account for in terms of economic damages, because that person could work the rest of their life and not make 30 mil. And we're not even looking at the fact that they would mitigate and they would find other jobs and everything else, right? So it's not the economic damages. And that person's walking around having a relatively fine life. They've certainly been harmed. Maybe they have a diagnosis, right? But their life is not over, right? And let's be frank, there's a lot of people who die, a lot of personal injury cases and medical malpractice cases where people die. It's not worth 30 mil, right? So, frankly, you can't really account for 30 mil in an emotional damages verdict most of the time. I'm not saying it couldn't happen. I'm just saying it's probably not going to happen. Statistically speaking, very unlikely. So it's not the economic damages. It's not the emotional damages. Is it the punitives? Well, punitives are more discretionary to the jury, so it's probably not going to be a situation where punitives are struck down by a judge in quite the same way. So we're going to set punitives over here. Listen, they can certainly be knocked down by a judge, but it's a little less likely, and it's a different situation, right? So you got a verdict of 30 mil, and you can't explain it. You can't explain it with the economic damages. You can't explain it with the emotional damages. Everyone who looks at it, who understands the formula, fundamentally knows, well, this is bullshit. The jury got it wrong, or a jury didn't care. The judge comes in and says, yeah, didn't apply the jury instruction correctly. Didn't do the formulas right. Whatever it is, I'm going to reduce this. Go ahead and appeal me if you want to, plaintiff's counsel. But here's what I'm doing. Now, winning big and getting reduced is better than not winning at all. And it's better than winning small. Now you get to go to appeal and fight about it. And there's a good chance that you can probably settle this case somewhere between 3 mil, which is what the judge reduced it to, and the 30 mil the jury gave you, right? Because there's a chance that you might get an appeals court to overturn the judge. Also, it's very expensive to fight with you in an appeal for a long time, so you might get some settlements there. So it's not you're better off to get the big verdict from the jury and then have it reduced, but you'd rather have just the big verdict not reduced, right? That's generally not going to happen. And there's a lot of clients and a couple of attorneys who just don't get it. They can't get it. And you'll have the conversation like, listen, you can win this case 10 out of 10 times, but you're never going to win that much money because there's no way the formulas can stretch to make it to that amount of money. And they'll say, but you're saying there's a chance. And it's like, well, no. The jury can give you any number they want. They can just write 11 billion on a piece of paper, right? It doesn't mean you're going to get it. The formulas matter. The law matters. The judge has some power and some say in the situation. We're not making up numbers here. I understand why it feels like we're making up numbers. But listen, if you're, living a relatively happy life, probably you don't have 30 mil in emotional damages. And if you're not making, 2 mil a year, probably you don't have 30 mil in economic damages. Again, it can happen. Certainly there's cases where it has happened. They're incredibly rare. They're statistical improbabilities. And certain conditions have to be met for those things to take place. A lot of times you'll see an article in the media and go, oh, this case won 30 million. Yeah, that person's probably not going to get that. And then when reporters call me up and they're like, why didn't they get it? It's like, well, because that was a fake number. Like, that was just someone who doesn't understand saying nonsense. And that's not their fault. It's not their job to be an employment attorney and work with these formulas. They were trying their best, but it doesn't change the fact that the judge isn't going to be like, well, I don't care about the law. Let's go ahead and just give you this money. Not going to happen. That's so Apocalypto. When you ask me like the why and the how, that's the why. The how is the judge has the power. The recourse is you file an appeal to say the judge knocked it down too much and it should go back up. You probably can't argue it should be 30 million because you probably don't have a legal argument for that on appeal. You might. You certainly, if you have one, you would make the argument, but realistically speaking, you might not have an argument. And you got to be careful making arguments on appeal that don't have merit. You got to be very careful with that as an attorney. So, listen, you got to make the argument that has merit, which is, hey, judge knocked it down too much. We can agree perhaps the formulas were not applied correctly. 30 mil was not reachable in this situation. Although if you have punitive damages, you're going to certainly argue. You're going to make arguments around that. But while we agree that perhaps 30 mil was not reachable, the judge knocked it down to 3 mil. And I think we should be at 14. I think we should be at 14 mil for my client. And then you fight the fight and you have the appeal and you try to protect your verdict. And you talk settlement with the other side. And maybe your client wants to settle, maybe they don't. But probably they do want to settle for some amount greater than 3 million if they understand the realities of the situation and how the appeals court is probably going to find. I hope this helps, Apocalypto. As you can all see, I'm in New York today, so that's lovely. There's going to be a curtailment tomorrow, which means that this office building will not be allowed to run its AC because New York State and New York City, in all its wisdom, has not properly planned to produce enough electricity to operate New York City on hot days. Specifically, it's going to be 96 degrees tomorrow. So I'm going to be in a giant glass box, giant glass greenhouse, slowly getting cooked without AC tomorrow. Very exciting. Love it. If this video was helpful, like, subscribe, comment down below, share the channel so it can grow. Thank you, everybody. Take care.